So as you can see, there's a very familiar symbol at the background. Okay, this is what I'm sharing. The CE mark. Yeah. So this is copyright. I believe this is one of the most famous or well-known term in the IP, apart from trademark, which is copyright. Okay, I want to copyright this, I want to copyright that, I want to protect this by copyright. I often hear this. So what is actually copyright and what can be copyrighted or what can be protected by copyright? Yeah. So now Mr. Anthony Tay will share with you guys what copyright is about and what if your work is found in the public, what can you do about it? Yeah. Hi, Mr. Anthony Tay, please share your handsome video and unmute yourself.
Hello, can you hear me?
All right. Yeah.
Hello.
You're
can
clear.
Everybody hear me loud and clear?
Yes.
Okay. So without further ado, basically what Marcus has just explained, I'll be going through some very basic idea about copyright. Copyright is actually a very vast area, otherwise it wouldn't have its own, I would say, a specialized course or a specialized course or modules in all law programs. It serves as a major standard in terms of law. So I wouldn't bore everyone here with what the insight or very deep part of the copyright, because it definitely will bore everybody out. So I will go through what more concern about businessmen has in mind, whether they do have copyrights in their own business, and what else should they be aware of, and whether their works has been entered into public domain. Because there's a lot of misconception around SMEs that whether my work has been entered into public domain and whether anything from net is automatically equals public domain. So I will go through every single one of them and break down every single one of them and explain clearly what is all copyright is about. So I will basically share my screen now with all of you.
All right, thank you, Mr. Anthony Tay.
So may I start?
Yeah, please.
All right. Okay. So as the title shows, I will be talking about where, when, and how does a copyright come into existence and creation until it perishes from your sight, or basically from your grasp. So first, I'll be go through all these 4 important keynotes, which is the common types and the requirement of a copyrighted work, which is everybody's concerned about, and the public domain, what does it mean for copyright, and whether you are at risk of infringement or at worst criminal liability for copying someone else's work or even steal someone else's idea. So this is very important in terms of copyright. So go through very swiftly on the types of copyrights. I know everybody is busy worrying about the MCO and whatnot, and how will their business sustain amidst this MCO, even though they mentioned it's only 14 days, but you may, as through experience, you know, we tend to be extended on and on and on. God knows when the MCO will be lifted. So I will go through these things very swiftly so that all of you all can go back to your daily doings. So Malaysian do have a Copyrights Act, and I will only focus on copyrights in terms on a Malaysia perspective. So we do have our own Copyrights Act, which is the Copyrights Act 1987. So under Section 7, we do have several limbs of copyrightable works, which is literally musical works, artistic, film, sound, recordings, and broadcast. So we also do have things known as a dramatic work, which come in hand with any combination of the one I mentioned above in Section 7 of the Act. This could consist, because dramatic work tends to have a lot of dramatical performances, musical performances. That's why dramatic work can consist of a lot of different kinds of works in a single dramatical work. So these are all the common types of copyrights which you will see around the industry. So some examples. So we do have some, I will lump everything into 4 different examples. So we do have the artistic work, which you will see very commonly arise in paintings, photographs like your selfies, and you hire someone else to take photographs, like advertising materials or models, modeling for your product. Those are copyrighted work known as artistic work. We do have engineering drawings, which is sketches and blueprints drawn by engineers and architects. And of course, we do have artistic work like sculptures, like your statues, and even buildings itself could be a part of copyright. And the literary work is more towards the academic side of the industry, which is like books, articles, and journals and scripts written for movies and all. And we do have some, if there's a academician in the public area, so your research article or even journals which you wrote for your KPI, for example, those can be copyrighted. We also do have some musical works for some artists in Malaysia, which is your songs, music, rhythm, and musical notes. Still comes under musical works. And last but not least is the remainders of the copyright, which is films, broadcasts, and sound recordings. Though these could come in like the shapes of movies, podcasts you hear from, or even some broadcasting from radios and FM. Those are actually recorded in and it's subject to copyright protection. So what will be the requirements and validity for a copyright in Malaysia, or let alone is actually it's more like a requirement and validity for copyrights all around the world actually. As long, I think now majority of the big nation in the world is a member of the Berne Convention. So as long as you're a member of the Berne Convention, copyright protection will automatically arise for your works, as long as you fulfill the requirements and validity, of course, subject to certain rules and regulation in the respective country or jurisdiction. But this requirement and validity will be strictly scoped or sculptured in the image of Malaysian law. So the requirement is very simple. For copyright work, we only need three major things in, not really that major. In my perspective, there's only two major things which you need to fulfill. The first thing is the originality. So unlike patents and designs, where novelty is an important key factor, but for copyrights, we look at originality and not novelty. And as long as your originality ideas comes into a material form, which is written down, even take down snapshots, or even drawn out, written down in the material form, which is recorded form. And last but not least, you are a qualified person. The qualified person here doesn't mean you need to have a degree, a PhD, or whatnot in order to be a qualified person. Under the Act, qualified person means you're a resident and a recognized person in Malaysia itself. That's what qualified person means here. So we do have something special speculating around the minds of a lot of copyright owners where they will ask, what about my quality? What about the purpose of the creation of my work? Well, I need to tell you that originality and quality comes hand in hand. It's not equal to one another. Quality or purpose of a copyright doesn't matter. Even you have a very hideous or ugly photos taken, or the images is blurred out or whatever, that itself could be deemed as an art, maybe by certain artists, or it could be also as a work of an originality. So it doesn't matter whether the quality or purpose of your creation, as long as it's written down in material form and it's original, it will be protected by copyright. I hope I did not lose anybody there. So I'm not sure whether you are able to pause in the middle, but we do have a Q&A session towards the end if you have any question, or you can just type it out in the Q&A column in, I think Zoom has this function, I'm not sure. Okay, so I'll go through it. So what is copyright actually? So it's essentially, it meant protects an expression. So you have an idea, but not the idea itself. So a lot of people have different kinds of idea, but those ideas in your head itself doesn't protect, we don't protect it, but we protect your expression of your idea itself. So most of the time people were lost in this particular sentence. So I would make it more clear cut for you. Assume this cute minuscule humanoid here is you, and you have an idea, which is a light bulb. And after some skill and effort, you have written down a stack of books or novels or programs or even journals and whatever research paper. You have written down all the things. Copyright protects that particular stack itself, but whatever it is in your head, it's not protected, which is the light bulb itself. We do not protect the light bulb itself, but we protect the stack of the book itself. So this is what we meant by protect the expression of an idea, but not the idea itself. So I hope everyone is clear on this matter because it's very important. Okay, next we will move on to the lifespan itself. So how long does a copyright subsist in a particular work? a lot of people may have heard that a copyright lasts forever, but from a legal perspective and from the wording in the layman understanding, yes, it may last forever because it's throughout your life. Yes, it's correct. It's throughout the life of the creator plus 50 years upon death. But if you see, different authors may have different lifespan and accidents to happen, unfortunately. So the creation of the work would only last throughout the life of the author itself, plus 50 years upon death of the author. So from the date of death, plus another 50 years from that particular date. All of these works will be enjoying that particular lifespan itself, no more and no less. So once the period ends, it will enter the public domain. That's where the public domain comes in. Of course, there are multiple ways where a work can be entered into the public domain, which I will explain later. So all of this is a basic idea. 50 years is the years provided by our Copyright Act in Malaysia. There are certain countries which grants up to 70 years, even 90 years upon that. So that is very dependent on the work, on the country itself. So some of you all may think, what about joint authors? And what about work commissioned by a company? Or you are an employee in a company and you created a work during your course of your employment. And commission basically is commissioned by an employer. So what about these work? Do they enjoy a certain lifespan? Well, of course, they do enjoy a certain lifespan, but because I will go through the joint author first. The joint author is relatively simple and straightforward. If you have 2 or 3 authors in a single copyrighted work, obviously the lifespan of the work will only start running upon the death of the last author itself. So if the first author passed away, okay, the duration will still continue to run throughout the lifespan of the remaining author, which is still alive, which will only start running after death of the second author or the last remaining author. Only that the time stream will start running from that onwards. So in terms of work commissioned by a company or an employer, this is usually there's a lot of dispute, copyright dispute arise during majority of the part for this sort of issue. If you're an employee and you're commissioned by your company to come up with a copyrighted work, unless you have a separate agreement stated otherwise, in default position, all copyrighted works will be owned by the company itself and not by the creator or the author. Almost all employees don't own any single copyrighted works in a company because you have conducted the work during the course of employment. That would be a different story if you have, after working hours, you went back home and you created and you return and you express your own idea in your own personal free time. That belongs to you. But what are the matter here? The keyword here is during the course of employment. So and of course it's during working hours. And of course you are a contractor or subcontractor. Someone hired you to take a photo of a particular advertising brand or a product image for advertising purposes. The photographer, under normal circumstances, if he snap picture in his own free will, of course, that work would belong to the photographer. But if that work were to be hired by someone else, in default position, that would belong to the person who hired the photographer. Hence, you would see a majority of the advertising company now before you actually hire them, they would give you a contract, which actually grants them permission, grants them the rights to own the work. So the moment you sign the document, you will not own the copyright until you pay them until you fulfill certain conditions. For example, you pay them in full, or maybe you have completed every single things and until the surrender of the rights of itself. So I hope everyone will get that clear on that part. So we do have a thing in Malaysia and certain parts of the country, we we call it as voluntary notification of registry. Copyright do not require us to be registered in order to be enforceable. As I mentioned, as long as the country itself is a member of the Berne Convention, copyright will be automatically protected as long as you fulfill the trade requirements, which I mentioned earlier, and it need not be subsequently registered. But Malaysia, we do have a system, we call it voluntary notification system, where owners of copyrighted work can deposit their work with the government. In our Malaysian case would be MiniPTALK, the Malaysian Intellectual Property Organization, where the Malaysian Work Authority would keep it and notify in record that this particular work has come into existence, and they will keep a record of it. And it will obviously reduce the dispute among co-owners, whereby you insert the date, the owner is who, the author is who, Does the work actually has been assigned? Everything will be recorded in a paper, in a paperwork form of way, so that no dispute will arise. And of course, there's no renewal required. As long as you deposit it in, it only need to do it once for each creation of the work. And of course, it is useful evidence for enforcement, because like Malaysia, a lot of people are very stubborn, stubborn Malaysians, and even they wouldn't admit they are copying your work. Despite you have warned them multiple times, they would just say that I created this work on my own free will. They wouldn't admit to whatever they are doing. So a registration, or not a registration, a deposit of the copyrighted work via the voluntary notification will give you a sort of an edge towards this kind of thing, where you would have a copyright certificate, which is as shown on the image now. So with this certificate, it can be used as evidence of enforcement, either through your own will by serving a cease and desist, or it could be even used as an admissible evidence in court if the matter were to escalate to a court setting. Okay, so it's a very useful system. I would strongly advise all of you to make use of the system. It do grants a lot of convenience to copyright owners. Okay, moving on to our second part of today's talk, will be the public domain. Public domain has posed a lot of concern, and certain owners, they do aware of the public domain issue of their work, and they the very famous example would be, I think, in the news like 2 years back, where Mickey Mouse, the signature Mickey Mouse, the figurine Mickey Mouse, the original icon, which is the black and white version of it, not the modernized version where you see in Disneyland, not that kind, the original one. I should have prepared a YouTube video for you all to look at. I believe you all could grasp the idea, the black and white version of it, and it's soon entering into public domain. So how to protect the thing which is going to enter into public domain? Mickey Mouse is a very famous mascot. Of course, Disney is not worried with their issue whether the Mickey Mouse will enter in the public domain and anyone else could copy the Mickey Mouse and use it on their product. Of course, they wouldn't allow that to happen, which is why the Mickey Mouse, the mascot itself, is a registered trademark. Trademark in comparison to copyright is a forever thing. As long as you renew it every 10 years, and it will ultimately belong to you. But the issue is not about trademark today. So I will go through the public domain part, how to maintain, what constitutes a work by entering into a public domain, or how to avoid things entering the public domain. I think copyrights entering the public domain is an unavoidable issue. Everybody knows that. Things would obviously go entering the public domain unless you protect it under different parts of IP, which that would be a different kind of story and in a separate talk, or you can go through back to my earlier talk for what do's and don'ts for trademarks. There I will have mentioned how to protect your trademark. If you have a particular mascot which is originally protected under copyright, there's no stopping you from protecting it under trademark. So you can go find it out yourself. So due to time constraint, I will go through swiftly. What does it mean for copyright if it's entered into a public domain? So public domain means a work which is free to use by everybody. It's not protected otherwise by other parts of IP, of course. These are free works where you can download it, use it, distribute it, copy it, even amend it, improvise it. That is up to you, because there's no one stopping you from doing it. That's public domain work. And how to determine it? So basically the first thing is, as I mentioned, expiration of the copyrighted work, which is a very, very long time expiration. So you do see like a very famous play or a novel or play, I would say play by Shakespeare. Romeo and Juliet is a work which has entered the public domain. So you could see a lot of different kinds of movies, shows have based their play on the Romeo and Juliet. And of course, they need not pay any royalty for it because it's already expired. So this is one of the very good examples. Or even some musical works like Beethoven, Mozart, all those are thing or musical work which has entered public domain. Hence, you would see a lot of different kinds of shopping malls or even restaurants or some high-end fine dining restaurants. They would play this kind of music because they don't subject to any royalties. But do correct me if I'm wrong, because under my understanding, these works have long, the author is long dead by now. I think it should have been entered in the public domain, but I'm not sure whether someone else has protected it via other means like Soundmark, for example. I'm not sure. So these are some common examples. So another thing is works which are not fixed in tangible or material form, as I said earlier. So as long as your work kept in your head, it is public domain work. because anybody can come up with an idea same as yours. So as long as it's not fixed in material or tangible form, it is a public domain thing, which is free to use by everyone. The last is the works which are lacking of sufficient originality. This is a very thing which has caused a lot of dispute, because what is originality? Because it's very hard to determine originality, and copyright dispute ends up in court is for the judge to determine whether this infringement, whether the derivative work for the particular work is sufficiently original, and whether it has entered the public domain, and whether it's correct, it has entered into a public domain. So I would not say that the work is lack sufficient originality would render certain things enter into public domain. But it's a very subjective matter, and unfortunately, Malaysia copyright cases are not that substantial in terms of originality. So I'm afraid I can't show any examples. But here is one of the things, as long as your work lacks sufficient originality. For example, you simply just come up with an idea, and the work itself has been used by many, the idea itself has been used by many, and you're trying to claim that that work is yours. Of course, it's impossible, because everybody has been using the same idea on and on and on, and you cannot possibly claim that that particular idea belongs to you, which is unfair, because there's no originality whatsoever. So I believe this could explain well what does it mean by lacking sufficient originality. So some examples. We do have certain things which can enter in, which is originally comes in the public domain, which is federal legislative enactments, which is a public announcement from the Prime Minister officer or the Parliament. All those are all those are public domain materials, which is not copyrightable. We do have book or movie titles. The book or movie, the keyword is titles. The titles itself is not copyrighted, but more towards trademark. And history or news, those are not copyrighted, because these are reality fact, which is a public available information, and public need to know this, and of course need to distribute it and spread around for public knowledge. So these are not copyrightable. Procedures, method, and systems, all these can be protected elsewhere, but definitely not copyright. Ideas and concepts, as I mentioned, everything stuck in your head, which is a public domain concepts. And some researchers tend to claim that they have a rights on certain things, which is principle or discoveries. Sorry to tell all the researchers out there, principles and discoveries are not yours to begin with. Basically, you do have a skill and effort by discovering this material, but it's a gift of God or an act of God. So it's basically it's been out there. It's just that no one has discovered it. So it's not copyrightable under you personally, because you do not create it by yourself, but created by God or some natural phenomenon. So you cannot claim that these discoveries or principles belong to you, something like mathematical principles, because everyone could create certain things like this. Or given some time, a person with your similar skill and background could come up with the same principles. So these are not copyrightable by the prospective academician or researcher. But it can be, I'm not disputing it, I'm not denying it can be protected in other areas of intellectual property, for example, patents, for example. We do have method and system patents, procedure patents, all those that can be protected in elsewhere in terms of patent, but definitely not copyright. So then you would come up with an idea, which is the main thing behind your head. What about things on the internet which have public access? Yes, a lot of people like to go Google Images. Like for example, my emojis, I have downloaded it from Google Image. But am I in infringement of copyright? Yes, I am in infringement. If I were to distribute my slides without removing the emoji and distribute to all of you, yes, I'm at risk. So hence, but for current purposes, I'm not collecting any payment by telling you this. I'm not distributing yet, but I'm mainly using it for the purpose of academic purposes, which I'm actually informing you all what should and should not be due for copyright. So I'm actually I do have a defense for fair use, because I'm using it to inform you for academic purposes and research purposes that what about things to have? What about things that have uploaded on the internet, and whether simply downloading it or using it for commercial purposes am I at risk of infringing another people's property? So I will tell you that by using this myth about copyrights and domains. Okay, so I don't know how many, let me see how many participants are here now. Am I able to see it? I know, maybe I'll ask Marcus later. How many participants is here? It's better to do it that way, because this is actually need to have a show of hands and one of them. I don't know how to look at the hands. We do have 7 participants. never mind. I won't go through that because it's a time-wasting effort. So here
You'll be
are
able to
some
see the show of hands on the participant screen, yeah?
really,
You will see
okay,
this logo,
I will see this. Okay.
Yeah.
So if let's say the symbol, okay, so if you think that the matter is the statement is correct, it's true, please show your hand. If it's false, do not show your hands. Okay. I will go through it by looking at whether you grasp your basic idea about copyrights. Okay, first, the symbol C is not there, so it's not copyrighted. Is it true or false? I don't see any hand. Let me see. Why is this out? Oh my goodness. How do I close this? All right. Oh, I think someone see my, okay. Yeah. The first thing is obviously it's false. As long as the symbol, even though the symbol is not there, doesn't mean it's not copyrighted. It is true in the old days, but not so true now because, as I mentioned, the majority of the countries is a member of the Berne Convention. So even though a symbol is not there or a notice is not there, doesn't mean it's not copyrighted. As I mentioned earlier, if you pay attention to what I said earlier, as long as the matter has sufficiently fulfilled the requirement and the requirements provided under the respective law, so it is copyrighted work as long as reduced to material form is original and by a qualified person. And of course, even though the symbol is not there, doesn't mean it's not copyrighted. So it's false for this statement. The second one would be, I do not charge for a fee. Am I infringing anyone? As I mentioned earlier, I did give out a hint. Even though you are not charging for a fee, the statement for this would be false. So even if you do not charge for it, you are not doesn't mean you are not infringing anyone. Because copyright works allows the monopoly rights by the author to reproduce, to copy, and to distribute the things to another. That's the exclusive right for the owner and not for anyone else. So even you are not charging anything, it doesn't mean give you the right to distribute a copyrighted works, because in a certain way or indirect way, you may damage the reputation or you may reduce the value for a particular copyrighted works. So the third statement, if it is posted on the internet, then is it in the public domain? That is a big question here. So the statement here, I would just straight away go tell everybody it's false. Even though things are posted on the internet, it is by way of the author to share and to publish their works. It's not for you by means for it means to have entered into the public domain. Unless you see certain statements by the author, which is unlikely, I hereby grant this work into the public domain. Unless you see this sort of statement or anything to that effect, it doesn't mean that anything posted on the internet has entered the public domain. And this includes all those stories and pictures, photographs posted on Instagram, Facebook. It doesn't give you the rights to copy it, say screenshot it, and then post it for your own use. It doesn't give you that right. So you have to make it very clear. So what if you want to use a particular thing? Very simple, one word, ask. You need only to ask for permission from the owner before you can use it. If the owner thinks, yes, you may use it, then by all means you can use it. So the fourth statement, no one could ever steal away my work if I do not defend it. Well, anybody has any thoughts on this? No one raised hand. Never mind. Let me just shock some you here. Okay, the statement today is true. So no one could ever steal your work, even you don't defend it. Unlike trademarks, if you don't defend it, your trademark will be stolen by another. That's true for trademark, but it is not true in terms of here for copyrights, because as I mentioned, copyright is unlikely to be stolen. That's a fact. It's unlikely to be stolen by anyone because it is an automatically right arise and protected and only exclusive to the creation and the creator. So even you don't defend it, it doesn't deprive you of the rightful rights towards the copyrighted work. And this statement is correct in this particular sense. Even you don't defend it, you are still entitled to that particular work. So it just renders you more troublesome to go and sue the particular person for whatever things which rightfully belongs to you. But please don't have the mindset for other parts of the IP. Trademark, for example, you have to defend your trademarks, otherwise it will be lost to another for real. Okay. So the fifth, 1, 2, 3, 4, 5. Yes, the fifth statement is, I'm inspired by another to create something of my own, and therefore my new work belongs to me. Well, this I also have heard quite a lot from some client of ours, and they have always come here and say that I have derived something by using famous mascot, famous brands, and I created this. There's no right or wrong answer for this, but I would give this statement a false. Under our law, derivative work is a form of infringement, that is for sure. But at the end of the day, put it in a layman's perspective, it actually depends on the owner, whether they do mind about it, whether they are flattered by it. Because of course, big brands like Starbucks, McDonald's, KFC, as long as they don't mind with it, they treat it as a free advertisement. But please put a fine grain of salt on the word free advertisement, because if certain owners do mind, they will come after you, because you may be thinking you are giving free advertisement. Oh, that will be the last statement. I will go through it in my last statement. Okay, so as long for this statement, it will be false, because the work does not belong to you, because you have based your inspiration on another works and you derive your new work from that original work. Of course, it's a form of derivative work. Hence, it will be infringing someone else's original work. So this statement itself here is false. So try not to create something which is deriving from another person's, because that work would render the originality at jeopardy. So the sixth statement is violation of copyright is a crime. So is it a crime in Malaysia? The statement to this is true. It is a crime in Malaysia. If you were to go to the movie theater, you would see a copyright notice before a movie starts. So that itself, it actually gives you some jail terms and fine. I will go through more detail towards the back of my presentation. So violation of copyright is a crime. That is true. And the last but not least, the free advertisement part. Owner would love it since I advertise their work for free. So this is only your thinking. So what makes you so sure that the owner would love you to advertise for them? Did they ask for it? They did not ask for your free advertisement. So don't think so full of yourself, thinking that the owner wouldn't mind. Because unless you really know that the owner don't mind, don't advertise for them. Before you advertise certain things for free, you still need to ask the owner whether they mind you advertising their product or using their work to advertise to print on your product. For example, for example, this is purely fictional. There's a Malay brand or Malay mascot. You really love the mascot, being Malaysia and all, you want to cover for all races so that it's more acceptable for all races. But that particular product you are selling is actually not really that acceptable, or even is haram to an extent, is haram towards the Malay public. And you want to use that particular work on your product. Of course, they would mind if you use it. So the best way, if you want to use a certain work, if you love the work, better ask, because certain owners, they wouldn't mind you use their work, because it gives them more way or more channel to broadcast or promote their work, which is what they want. So in certain areas, owners do mind. So the best way to do so is ask before you advertise for them. So the statement in here is false. So not all owners would love a free advertisement, frankly speaking. Okay, I hope I did not lose anyone there. So let's go to copyright misappropriation. The word misappropriation here essentially meant stealing. Okay, am I at fault for stealing someone else's work? So Malaysia is governs under the section 36(2) of the Copyright Act. So of course, anything copying, everything selling, distributing, trade exhibiting, or whatever, which you ought to know, reasonably know that thing making or carrying out or distributing certain things without the consent or owner of the copyright is a form of infringement. So that is a very straightforward fact. So it's a civil liability, of course. If the owner decides to sue you, of course you'll get sued, and they are able to claim damages for whatever you have been selling, your profit. They will calculate on a certain sum and sue you for damages, and even their reputation itself. These are for infringement, which is a civil liability. There's no jail term for it. It's a purely civil. Okay, so how to determine an infringement? Very simple. There's a case law here in Malaysia, the Magnaway Enterprise against Sun Lia Hock. So basically, there are three things we need to consider before you could determine an infringement. First, you need to have objective similarity. This is a very objective thing to do. As long as there's two products in front of view. If the things are materially similar to one another, objectively similar, I see the product itself, there's no sufficiently difference from this. Of course, I would deem this to be objectively similar. Of course, there's a causal connection between them. The products is essentially the same or have the same nature. And last but not least, a substantial part of the original work has been infringed. Because a work is, for example, a novel, and there's a climax part. Every single novel or storyline has a climax. And if, let's say, that particular climax of the part has been copied and move on in another storyline, which is totally different, has a different plot and whatever, irrespective of the plot, if that particular storyline has been carried out in a different work, that itself would be deemed as a substantial part of the original work. Hence, it will be falls under an infringement. It is held in this particular case that it could be an infringement, of course, if it's an exact replica. Size and portion copied does not matter. I know I would disregard whatever things, the size you copied or the portion of the work you copied, it doesn't matter. It's not a determining factor. The more determining factor would be the degree of similarity. A higher degree of similarity means you automatically establish a higher degree of substantial similarity. Hence, there's a prima facie presumption. I would presume you have infringed this particular original work. This is how we determine copyright infringement in Malaysia with this particular Malaysian case law. I hope everyone will have a basic idea. Try not to infringe on other people's work by copying someone else's work. So this is a warning from our side. Okay, some visualization. To some Pokemon fans out there, if you will know that this Pokemon games itself is a copyrighted material. So you will see there's two screenshot or GIF images here. The one on the left is the original work by Nintendo. The one on the right is a fan-made. I think the one on the right is a fan-made version of Pokemon. If you can see from the images, they are essentially the same. The same play style, the same the catching things or whatnot. The concept and idea is the same. As I mentioned earlier, the concept and idea itself is not a form of infringement. It's not things protected by copyright law, but the expression itself. If you can see the expression of the idea here by this particular fan, they have made it out this way. And of course, there's no consent whatsoever from Nintendo and have created this back in 2016. This particular game is called Pokemon Uranium, which is a fan-made free-to-download game launched in August 2016. It's an unlicensed product, but hit 1.5 million downloads in a week. Of course, such a huge hit, of course, wouldn't go unnoticed by Nintendo, which is the original owner. So Nintendo do have issued multiple takedown notices to this particular fan. Of course, the fan wouldn't have known that, whether distributing a copyright, as long as the fan would have a basic idea, I'm not charging anyone, it's free for download, everybody can go download. But the same idea would still apply here. If Nintendo doesn't mind, of course, there wouldn't be any issue. But in this particular case, Nintendo do mind, and they did send a multiple takedown notices. They haven't sued the fan because it's still a fan. So, in a press statement, the owner, which is the creator of this particular Pokemon Uranium, they did mention, while we are not personally have been contacted by Nintendo, but they are contacted by their lawyers, it is clear what their intention are, Nintendo's intention, and we respect those intent. Basically, the fans respect Nintendo's wishes and have taken down all the download links and whatnot to access to these particular games. So, and they have discovered that not selling their work doesn't mean they have the right to distribute it. So this is a very big wake-up call to all owners or to all SMEs out there. Even though you are not selling it, doesn't mean you have the right to distribute it. So this is the key essential fact between, because a lot of owners may have a basic idea, if I'm not commercializing it, I'm not at fault. But this particular example here tells you that even though you are not selling it, you are still at risk of infringement if the owner do mind that you are distributing their work without their consent or permission. So I hope you have a basic idea of what should and should not be done for copyrighted work. Okay, now let's back to some criminal liability. In Malaysia, yes, it is a criminal liability for copyright infringement, for copyright copying. And that is laid down under Section 41, Subsection 1 of the Malaysian Copyright Act. And of course, the long-winded things here essentially meant you make it and to sell it and you distribute it, you possess it, and by way of trade exhibit it in public and imports into Malaysia. And for the communication to the public with the authority, you have copies of the work. All this essentially meant one thing. Let me give you an example. Some visualization again. Okay, I have a fine print there, images not owned by us and may be subject to copyright. So you would see this in Malaysia all along. Some people carrying the bags have kept walking around to like some tasat or some restaurants selling this sort of DVDs in plastic films. All this, of course, people know they are pirated. Pirated DVDs is a form of copyright infringement, which could equal a criminal, which renders a crime liability. This is one of the examples, and this is some example as well. And the more commonly seen examples, I seldom see this kind of, due to MCO, I don't see them at all now. Here are some examples. Obviously I cannot record in the cinema. I wouldn't know that whether there's someone is recording. These are some photographs I found on the net. You record a movie while it's playing. This is obviously a crime. So better not to do so during, this would render you at a very big misdoing or offense under the Malaysian law. So better don't do so. And if, let's say, for example, if certain owner do mind, they are able to make a police report and saying that you have copied my work, apply on your product, and have sold for profit and possessing certain things of my own, and pirated my stuff, everything will fall under a criminal liability. So please be aware. I believe this will be my last slide. Oh no, I do have one more slide, which is the punishment part. You would want to know what is the punishment for offenders under the Malaysian Copyright Act for crime liability. It will be a fine, not more than 10,000 ringgit for each infringing copy. So if you look at the photographs just now, how many copies are there? They will calculate, they will multiply by 10,000, not more than 10,000 each, and imprisonment of no more than 5 years and a statement or both. Okay, subsequent offender will have a higher degree of punishment, which is not more than 25,000 for each infringing copy, and imprisonment of not more than 10 years or both. Okay, this will be the punishment for people who have infringing or copied or possessed certain else's work without permission. And thank you. Marcus, it's all yours.
All right, thank you very much, Mr. Anthony Tay, for your brilliant talk and for taking the risk of infringing other people's copyright to share with us your slide in your talk. Yeah, so Anthony, please stay with us for a while. Don't go first. Our speaker is always in a rush. Don't go first. While we get any questions from the floor, any questions from the audience?
Sharing.
Okay, don't worry. If you have any question later or when you're sleeping, you thought of anything, you can always be feel free to actually message us or PM us on our Facebook, NBS MY. Okay, still, Anthony, please don't go first. I have a few questions. I think the audience out there will be interested to know as well. Just now you mentioned about inspiration of work, for example, work that has entered public domain. For example, if I were to use Beethoven's music and I produce my own version of it, is it actually protected by copyright? Can other people actually use my Beethoven version of music in that sense?
Okay, there's two parts to that question. The first, I'm not sure whether there's any production company has claimed an ownership on Beethoven music. That one I'm not sure. So by right, Beethoven has passed away for hundreds of years. By right, all of his work would have entered a public domain. So there's no stopping any musician from taking his work and inspired from his work and created something new or original. So that itself is not in dispute. So that will answer your first part of the question. You are entitled to create something from Beethoven's creation. And provided there's no production company has claimed a right on the musical right on the music itself. That's the big if there. And the second part, so if you, let's say if your work were to be published and someone else use your work, of course you are entitled to sue that particular misuser for infringement because it's an entirely original work by yourself. So that would be answered for the second part of the question.
So how much of modification would be considered original for me?
Modification.
Like my version, how much different from the original Beethoven do I have to create to be considered original? for my work.
Original, right? It's not saying that it's a knockoff of Beethoven, right?
Yeah.
We do not have a right or wrong answer. As I shown the case of earlier Malaysian case, we do have to compare it on an objective way. We do compare the notes. For music itself, it's a very interesting part. In a lot of cases in overseas, they do use musical notes. They wouldn't hear a sound from in the court setting. If let's say the musical rights is a thing in dispute, they will usually use the music notes for comparison. In rare cases, they will play the music in court, but usually majority of the time they will use musical notes. The simple thing. Okay, so they will compare it side by side. If let's say if the court thinks that, or the judge thinks that there are substantial dissimilarity, they would deem it as original or deem it as sufficiently different from the original work. So that would be one way to determine. But it's a very objective. It may say objective, but in certain times it could be very subjective. It depends on how a human deems the music to be similar. A very good example would be Kesha's what's the song name? I can't remember. It's similar to Lee Hom's songs, Wang Lee Hong. I forgot the song's name. I forgot. Lee Hom actually has a new song came out not long after Kesha's song. And there are some public uproar saying that Lee Hom actually copied Kesha. But as a matter of fact, if you listen to both songs concurrently, yeah, they do have certain similarity. But at the end of the day, Lee Hom may have inspired by Kesha's song. I wouldn't know that. But overall, the both songs overall are different in nature, to be honest, are very different. So other than that small particular part, which everyone thinks the same, but there's no infringement from Lee Hom side. So at the sense that I may compare it objectively, I would say that this part here is similar. But from a subjective perspective, these two songs are essentially different. So at the end of the day, it really depends on a human perspective, a human touch.
All right. Understood. Thank you for clarifying this. And this leads to my next question. So, although Malaysia offers a voluntary notification for copyrighted work, right? But copyrighted works are also automatically protected. So as we see, like many artists out there for their paintings, they just sign their name and date their work. You know, is it actually sufficient to actually protect their copyright? What if the artist or the author doesn't do that? How do we actually know it's their work, and how is it actually protected? What do you recommend?
Okay. For are you referring to musical artists?
Yeah, musical or a painter's work, for example.
And you're saying that those who are commissioned?
Yeah.
Okay. Those commission work, basically, if you don't have anything signed or you don't have anything, that's why now it's very contract is very, because copyright runs hand in hand with contract law as well. So if you don't have anything signed, obviously the thing would automatically belongs to the person who hired you, as I mentioned earlier. If you don't have anything signed, by assigning the rights back, stating the position clearly, whoever pays you owns the work. That is a default position. So it's very important to have an agreement or contract at bay if you were to act as a freelance artist or freelance music composer. That's very important.
So how, if I don't, let's say on my painting or my musical note, if I don't put my signature on the note, or I don't write my name or date on the note, how do I, actually prove my work? How prove that thing is mine,
Of course, if you have created, right, that will be a neglect. You have neglected in doing so, because for now, I believe most artists would leave a signature or leave a fine print. But for example, music composer, they compose their music based on software, and software do leave a mark, leave some sort of marking. And for painting itself, generally all painters would have their habit. They would just sign the painting after they end it. If for example, if you neglected to sign it towards on the painting itself, that would give rise to some form of dispute. But of course, if you have witnesses, that would be fine. And in the old days, when the notification system is not there, people would tend to sign an SC, a statutory declaration, stating the creation date, the painting's title, and a snapshot, a screenshot or the painting itself, a copy of the painting itself, and slip in an envelope and mail it back to themselves. But they don't open the envelope. They don't open the envelope, but they keep it. So everything in there would have have stated that the things is original, everything will be in there. As long until one day there's a dispute, only then they will open the envelope and take the content out to prove that he is the owner. This is one of the, in a way, in the old days, without a system in place.
Okay, so it's a very important due diligence to actually prove that the work is ours by leaving our prints or do a registered mail to ourselves, or do a voluntary notification to the government.
Yes.
So
It's very important to leave a mark.
Yeah, so speaking of voluntary notification, I think that's the best way, right, to actually leave your work with the government.
That is definitely the best way. You no need to do a lot of things, because you leave the agents to do it for you.
Yeah, so how do I actually do that? If I have a work, how do I actually submit to the government? In what form is it accepted?
There are a few forms you can submit it, and the registry do accept a few forms, pen drive and CDs. And of course, they do accept paper as well, but papers are not really that recommended. We generally advise clients to file everything, put everything in the storage devices, which is like very small thing. Pen drive is the pen drive, and DVD is the most commonly used now, medium. And the fee charge itself is based on the size of the medium itself, but not on the total size of the work itself. They still charge on the medium itself. So it is best to get the medium size sufficiently enough to cover your work. Don't go overboard. That would be because the size of the medium determines the price itself, not the work size of the work. Yeah.
So it doesn't matter how big your work is, as long as it's a 4 GB DVD, then you would charge based on the 4 GB.
Yes, correct. Correct.
Okay. Is it expensive in this sense?
No, not expensive. Copyright registration in Malaysia is not really that expensive. It's like less than 2,000, you can get everything done already.
I see. All right. Thank you very much, Mr. Anthony Tay, for sharing with us today. I hope everything is clear for the audience. If you have any question, please message us on our Facebook PM, NBSMY. Yeah. All right. So we've come to the end of our talk. All right. Our next talk will be actually in the beginning of February. Okay. Watch out the NBS page. Like our NBS page. All right. And watch out for our new advertisement on the next talk, which will focus on IP and cyber squatting. What is cyber squatting? Basically, you falsely or you register other people's domain name, internet domain name, www dot something, right? Okay, you register other people's domain name in bad faith, in the hope to steal other people's mark, their name. So this is a bad act. So our next talk in February, we are going to talk about that. Yeah. So watch out, right? Thank you very much for attending. Hope you guys are doing well at home, working from home. Stay safe in this MCO 2.0. See you again. Bye.
Bye.
Thank you, Mr. Anthony.
I shall leave now.
Yeah.